Welcome to The Explainer. Today we're going to talk about something that's a real nightmare for a lot of homeowners, getting hit with a massive, out-of-the-blue fee hike from your HOA. We're going to break down a real-life legal battle to see how it all played out.
So let's just dive right in with the big question. Imagine opening your mail and seeing that your HOA is jacking up your annual fees by almost 40%. Can they even do that? And more importantly, what can you do about it?
And look, this number, 39.4%, this isn't some made-up number for a textbook example. Nope, this is the exact percentage increase that kicked off a major legal showdown between one homeowner in Arizona and his HOA. So let's get into the specifics. The case is Brad W. Stevens versus his HOA, Mogollon Airpark. We're going to unpack this whole legal battle, look at what both sides argued, and find out how the court finally put this thing to rest.
All right. First things first, how on earth do you even get to a nearly 40% hike? Let's look at the actual numbers and see what happened here.
Okay, so check this out. In 2017, the annual fee was $825, but the bill for 2018, bam! It jumps by $325, bringing the total to $1,150. Now here's the kicker. This jump came from two separate charges, a regular dues increase and something they called a special assessment. And that distinction, believe me, is what this entire fight is going to hinge on.
So Mr. Stevens gets this bill, and he's not just thinking, wow, this is unfair. He's thinking this is flat out illegal. And he built his entire case around one very specific state law.
And here it is. This Arizona law is the heart of the whole dispute. It seems pretty clear, right? There's a 20% cap. But you see that one little word in there, regular? Well, get ready, because that single word is what this whole legal war is going to be about. So with this law in his back pocket, Mr. Stevens files a petition, and his claim was, from his point of view, incredibly simple and straightforward. He basically said, hey, just read the law.
And his argument was actually pretty clever. He said, look, when the law says regular, it's just talking about the process. You know, a regular old board meeting where they approve stuff. And since the whole $325 increase was approved in one single meeting, he argued it should all be treated as one single assessment. The type of fee shouldn't matter, just the process.
So you see his logic, right? If the whole $325 is one assessment, created through one process, then the math is a no-brainer. A 39.4% increase is nearly double the 20% limit allowed by law. Case closed, right? Well, not so fast.
Because, of course, the HOA had a completely different take. They looked at that exact same bill and said, hold on a minute, that's not one fee, it's two.
The HOA fired back, saying that $325 was two totally separate things. First, they had a $116 regular increase for their operating budget, which, at 14.1%, was well under the 20% cap. And the other $209? They argued that was a one-time special assessment to beef up their reserve funds, which, and this is the key part, isn't subject to the 20% rule at all.
So there you have it, two totally conflicting interpretations. On one side, a homeowner sees one giant illegal 39.4% hike. On the other, the HOA sees two separate, totally legal fees. An administrative law judge had to make the final call. And the verdict? The judge sided with the HOA.
But wait, why? I mean, how could a nearly 40% increase possibly be legal? This is really the most important part of the whole story, because the judge's reasoning is a masterclass in how courts actually interpret the language of the law. It's a huge lesson for every single homeowner.
The judge's logic here is just fascinating. It really broke down into a few key steps. First, the judge said every word in a law has to mean something. If regular just meant done in a regular meeting, the word would be totally pointless. Second, the judge looked at other laws and found they specifically use both regular and special assessments, treating them as two different things. This meant regular had to be a type of fee, not a process. Finally, the judge decided the homeowner's argument could lead to some pretty absurd situations. So the final ruling was clear. Regular and special are legally distinct types of fees.
So what does all this legal back and forth actually mean for you? What's the crucial takeaway from this one case for any homeowner living in a community with an HOA?
The big lesson here is that words matter immensely. That tiny distinction between a regular and a special assessment was the pivot on which this entire case turned. It just goes to show you that the specific language in state laws and, just as importantly, in your own HOA's governing documents has real financial power.
We're talking about your money.
And that brings us to the final crucial question for you. Do you know how your HOA defines a special assessment? Because as this case proves, what you don't know could cost you hundreds or even thousands of dollars. The fine print isn't just for lawyers, it's your financial safeguard.